Introduction. General defenses. General defense are a set of defenses or excuse for a defendant to escape himself from holding liability with the act done by him to the plaintiff in tort. The defendant may avoid himself from having liability when the plaintiff brings an action against him by taking the plea of some defenses. There is specific defense which is peculiar to some defense. There are some specific defenses which are peculiar to some particular wrongs. There are some general defenses which may be taken against the action for a number of wrongs. For instances, the general defense of consent may be taken whether the action is for trespass, defamation, false imprisonment, or some other wrong. The example of general defenses are as follows. First, 𝘊𝘰𝘯𝘕𝘓, which is defense of consent. Second, plaintiff, which is the wrongdoer. Third, inevitable accident. Fourth, act of God. 5. Private defense. 6. Mistake. And lastly, necessity. Consent violenti non fit injuria. If a person happen to have been consented and assented to the doing of the act that will cause him harm in which he suffered from it, he will not be able to have any remedy in tort, nor complain of it as wrong where the consent of his will result to the complete defense to be pleaded by the defendant, meaning that the defendant will not have to pay him for any damages whatsoever. This effect of this consent given by the person suffering harm is expressly stated in the maxim of violenti non fit injuria, which brings the meaning of a person who suffered harm may not have any remedy in tort if he consented or at least assented. It was quoted from the case of Smith against Baker. The maxim is founded on good sense and justice. One who has invited or assented to an act being done towards him cannot, when he suffers from it, complain of it as wrong. The maxim will be effective in two ways. First and foremost, it prevents the defendant's wrongful conduct from being a breach of duty. The defendant will not hold any liability for committing wrong, as the consent by the plaintiff has been given to him in which the latter result of the defendant's conduct will then not be seen as a wrongful act. Normally, such consent is given before the conduct complained of and may be expressed in words as well as implied from conduct. In addition to this, secondly, the consent given by the plaintiff needs to be shown as the plaintiff has waived his right of action against the defendant. It means that despite of knowing that the act of a defendant is wrong in which it is a breach of duty owed to the plaintiff, but the plaintiff has assumed that the defendant's act of negligence may be risky. But in this case, the court has right in determining whether it was done voluntarily or involuntarily. The burden of proving it will be laid on the defendant as to give proof that the plaintiff has consented, that he, freely and voluntarily, with full knowledge of the nature and extent of the risk herein, and impliedly agreed to incur it.
Knowledge does not necessarily imply consent. The knowledge by the plaintiff is will insufficiently not constitute a liability to the defendant. If the defendant has done wrong to the plaintiff or the wrongful conduct by him has directly caused injury to the plaintiff, it still has to be shown by the plaintiff that he consent to the defendant by acquiring not to hold the defendant liable. As in this case, mere complete knowledge by the plaintiff of the source of the danger is not enough. Refer to the case of Bowater and Rowley Regis Corporation. A cart driver was asked to drive a horse which the knowledge to both was liable to bolt. The driver was not ready to take that horse out, but he did it just because his master asked to do so. The horse then bolted and the plaintiff suffered injuries. Here the plaintiff was entitled to recover. In Smith and Baker, the plaintiff was an employer to work on a drill for the purpose of cutting rocks. Some stones were being conveyed from one side to another using cranes surpassing his head. He was busy at work and suddenly a stone fell on his head, causing injuries. The defendant were negligent as they did not inform him. The court held that mere knowledge of risk does not mean that he has consent to risk. So the defendant were liable for this. The maxim voluntary non-fit injuria did not apply. But if a workman ignores the instruction of his employer, thereby suffering injury, in such cases this maxim applies. Consent must be free. The consent shall be given freely. It has been listed out clearly in the section 90 of the Penal Code of what does amount to consent. The consent will be vitiated. First, if the person giving consent is either under fear of injury, misconception of fact, or the door no, or has reason to believe that the consent was given as a consequences of such fear or misconception of fact. Second, if the consent given by the person of unsoundness mind or intoxication and does not know the nature of consequences of consent given. And third, given by a person under 12 years old. According to Stephen, a consent is said to be given freely when it is not produced, procured by force, fraud, or threats or whatever nature. If the consent is given by the plaintiff who is put under any kind of pressure, it will vitiate his consent. Refer to the case of 𝘔𝘰𝘯𝘴𝘦𝘯𝘓 and Mala Hospital. A 40-year-old married woman noticed a lump in her breast, but this pain does not affect her uterus. After the operation, she saw that her uterus has been removed without any justification. The hospital authorities were liable for this act. The patient's consent was taken for the operation, not to remove the uterus.
Consent of children to medical treatment. When it comes to raising children, you have a primary duty to act in the best interest of the child. When making decisions about treatment, children or young people should be involved in as many decisions as possible depending on their level of understanding. If the child is unable to provide their own consent, you will need the consent of the parent with the responsibility of the parent or, in some cases, the court to continue the treatment. According to Malaysian law, the age of minor is below the age of 18. The person under the age of 18 years old is considered as a children whose consent is according to the parents, either consent to surgical or medical or dental treatment. The prior consent from the parents or guardian or any person having lawful charge of the minor shall be obtained in the first place in order to get the treatment done as the children is incapable of giving agreement. Despite there is no consent freely given by the children, but instead it has been obtained by the parents, guardian, or the person having lawful charge of the child. They have been said to be protected by Section 89 of the Penal Code as it has been given for a benefit to a person who is unable of giving consent. For instance, a common occurrence involving this section is school teachers' infliction of corporal punishment on an errant pupil. The consent may not be given by the children to get punished. In England, once a person attains their 18th birthday, they are considered competent adults capable of accepting or rejecting treatment unless other factors prevent them from making the right decision. A child affirmative agreement for an investigation or treatment deemed in their best interest after reaching the age of 18 cannot be denied by anyone with parental responsibility, even though the court may be parent patriae. In fact, Lord Donaldson M.R. summarized that minors of any age who are guilty in the context of certain behavior are entitled to consent to treatment, which is again irrevocable by those who have parental responsibility but can be rejected by the court.
Younger than 16 years old, children under the age of 16 can get medical treatment if they understand what is being proposed, in which the understanding of a child is considered as gilid competita. The maturity and intelligence of a child will be decided by the doctor. Meanwhile, the parents cannot refuse the child's consent. What will happen if the child disagrees? In this case, it depends on the parent's consent, but it is also important to consider the necessity of removing the consent of the child. with the clinical situation given at that time. In addition, the competent child is legally entitled to refuse the consent, but there are also certain situations where the consent is vitiated as the refusal may harm the child himself. When consent can be overruled for children, if a minor refuses to get treatment that will cause death or permanent injury to them, consent no longer needed to give medical treatment. Their decision can be overruled by the courts. It is for the best for the minor to seek treatment. What happens if the parents withhold consent? If the responsible child refuses treatment and the parents agrees to their decision, but you do not believe that it is in the child's best interest, you should seek legal advice on how to proceed. The same principle applies when parents of incompetent children choose to reject consent for what you consider to be the necessary treatment. It is your responsibility to act in the best interest of the child, and this situation, despite rare, may be full and legal advice should be sought. Working with children and families to resolve problems is natural.
Comparison between English and Malaysian law. For law of England, it has been provided in Section 8 of Family Law Reform Act 1969 that a minor is able to give free consent voluntarily to any surgical, medical and dental treatment once he has reached a certain age, which is 16 years old. The consent given is valid, meaning that it is not necessary to get the consent from the parents, guardian or the person lawful in charge of the child. However, parents have various parental responsibilities in regard to their children and that they are given various rights in order to fulfill those responsibilities. One of the responsibilities to safeguard and promote the child's health, development and welfare. The parent also has the right to act as the child's legal representative, which gives parents the right to consent to medical treatment on behalf of a minor. These responsibilities last until the child reaches the age of 16. For law of Malaysia, in Malaysia, a minor is a person below the age of 18. He does not have the capacity to consent to surgical, medical and dental treatment. Those wishing to perform such treatment on the minor must obtain the prior consent of his parents or guardian. Section 2, Clause 12, Clause 1 of the Code stated that consent given by a child under the age of 80 years old is not valid unless the child is capable of understanding the nature and implications of the proposed treatment. If the child is not capable of such understanding, consent has to be obtained from the child's parent or legal guardian. The importance of the consent is to prevent the doctor from a claim in tort or battery of trespassing person. Age 80 is the age of majority, and before giving a treatment to a patient under the age of 80, consent must be obtained from the patient's parent or legal guardian. If the minor's parents have divorced or separated, they should decide which parent has the legal authority to consent to treatment given to their children. The court will usually grant one parent a primary care home with the right of visitation granted to another. It clearly can be said that the law states that a minor is incompetent to give consent for medical treatment, but there are some examples of this are as follows. 1. When a child under the age of 80 who lives without their parents or decisions may file petition the court for emancipation. If the court granted them or give permission, the minor will get a consent for themselves in order to seek for medical treatment. 2. A minor or a children who have a family, but the family is not living with them. The state may grant the minors the ability of get a consent to treatment on their own behalf. And 3. Minors allowed to consent to treatment such as substance abuse, mental health care and birth control. After a child gets a consent to treatment, the minor should be capable of understanding the nature and the consequence of the consent on their own behalf. Throughoutly, under what document or under what circumstances, the minor is allowed to consent to treatment. Section 2, Clause 12, Clause 4 of the Code also states, it is usually sufficient to have consent from one parent. However, in relation to major or controversial medical procedures, there may be the duty to consult the other parent. If the parents cannot agree and the dispute cannot be resolved, the doctor should seek legal advice as to whether it is necessary to apply to court for an order. This provision stated that if a parent refuses to give consent on a particular treatment, the court may give granted to minor to give consent on behalf of their medical treatment. If one parent doesn't want to cooperate by giving their consent, the court can make decision. But the doctors against their will have to force the parents to get an agreement. If the child's best interest cannot be reached, the court will make a decision. But if it's an emergency situation, waiting for the parents' consent will put the child at risk in matter of death or life. The surgery can be proceeded without their parents' consent.
Emergency situation. The Section 92 of the Penal Code provides that the situation of emergency is the situation where the act done by defendant is no wrong. It has been done in a good faith for the purpose of benefit of a person. It is done without the consent of the plaintiff, be it the person who has fulfilled the condition for the agreement but incapable of agreeing, or the minor who cannot give consent but also unable to get the agreement from the parent. This section also empowers a person who may be complete stranger to the victim to perform harm, causing act upon victim under certain restrictive conditions. Firstly, the child is underage but the consent can also be obtained from the parents, guardian, or the person who is lawful in charge, or second, the person of unsoundness mind. Third, the accused intended in a good faith for the victim benefit in performing the act. Lastly, the limitation concerning the type of harm and their purpose specified in the proviso to Section 89 were met. As a conclusion, the wishes of a child who has the capacity to decide whether to consent to or refuse a proposed treatment should be respected. However, the legal position in England and Wales means that in some circumstances where a child has made competent refusal of a treatment, a person with parental responsibility or the court may nevertheless authorize the treatment where it is in the child's best interest. Further, there are the laws in Malaysia that recognize children who are 16 years old and above but below 18 as competent to perform. It may be true that the implication of refusing treatment may be serious and perhaps even dangerous, but same can be said of a adult who refuses treatment. Once it is established that a child is competent and mature enough to have sufficient understanding to make decision, what justification are there for the parent overriding the decision of the child? Indeed, making a wrong choice is one of the consequences of judging someone to be competent and mature enough to make their own decision. The decision of competent children may be misguided, but again, so may those of adults.